The ICRC regional delegation, I welcome you to the second day of the ALKO ICRC workshop on international humanitarian law. This morning, following on from yesterday's discussion on international humanitarian law, new means and methods of warfare, and a discussion on the identification of the civilian and combatant and the notion of direct participation in hostilities, we take the discussion further in respect of the challenges relating to international humanitarian law and the contemporary armed conflict. Chairing this morning's session is an expert in His Excellency Gudmundur Eriksson. His Excellency received a Bachelor of Arts degree and the Bachelor of Sciences degree in Civil Engineering from Rutgers College in 1970, an LLB with honours degree from King's College, University of London, 1973, and an LLM degree from Columbia University in 1974. Ambassador Eriksson served as a Law of the Sea officer in the Office of the Secretary General of the United Nations for the Law of the Sea from 1974 to 1976, and as a special consultant at the Third UN Conference on the Law of the Sea in 1977. He joined the Ministry of Foreign Affairs of Iceland in 1977 with the rank of ambassador since 1988. And served as Assistant Legal Advisor for 3 years, from 77 to 80, Legal Advisor for 16 years, from 1980 to 96, and thereafter as Ambassador to Canada, Nicaragua, Colombia, Panama, Costa Rica, Ecuador, Venezuela, and Peru, from 2003 to 2005. Ambassador Eriksson was also a member of the UN International Law Commission from 1987 to 1996. He's the author of various texts on the International Tribunal for the Law of the Sea. He writes for the Nordic Journal of International Law and also served instrumentally in the development of what is today the Rome Statute of the ICC. We are very pleased to have Ambassador Eriksson chair this morning's session with two experts, the first being Professor Gandhi. And Professor Gandhi earned his PhD in International and Constitutional Laws from the University of Madras. And he holds a master's degree in International and Constitutional Laws from the University of Madras also. And another master's in Political Science and Public Administration from Madurai Kamaraj University. Professor Gandhi has served as legal advisor to the Ministry of External Affairs, Government of India. And during his service in the ministry, he had also served as member secretary to the high-level committee of the Government of India to formulate legislation on civil liability for nuclear damage. He had also served as one of the counsel for India in the case concerning the aerial incident of August 10, 1999, between Pakistan and India at the ICJ in The Hague. Presently, Professor Gandhi is Professor and Executive Director at the Center for International Legal Studies at Jindal Global Law School. Joining the panel is Mr. Dominique Barge. Mr. Barge was appointed as the Chief of Mission of the UNHCR in India and the Maldives in July 2013. Trained as a development economist, Mr. Barge has been with the UNHCR for over 20 years and served in various capacities with the Refugee Agency, including in Afghanistan, and most recently as head of operations in Dadaab. He was seconded to the Department for Peacekeeping Operations, DPKO, in 2005 and subsequently attached to the newly created Peace Building Support Office in the Office of the UN Secretary General. Ambassador Eriksson.
Yes, good morning. I thought for those of us who were not here, we would have a short recap of the discussion yesterday because two of the issues are relevant to our discussion today.
Mr. Chair, thank you very much for the opportunity to provide a recap of yesterday's discussion. The inaugural session of this workshop featured overviews of the Secretary General of the ALKO, Secretariat, as well as the head of the ICRC regional delegation on the nature and purpose of the workshop. Based on a cooperation agreement between both institutions dated 2002, the ALKO Secretariat and ICRC continue to work in partnership on the promotion, dissemination, and development of international humanitarian law specifically, but public international law generally. And so, in keeping with this cooperation agreement, the first substantive panel of yesterday's session focused on the work of ALKO in respect of IHL promotion and dissemination, and wherever possible, implementation. ALKO has as one of its priorities the implementation of public international law based on international commitments taken by ALKO member states. With us, Mr. Chair, of course, are ALKO member states, and for purposes of this session, observer states. And we looked closely at the challenges which confront international humanitarian law based on the changing nature of the battlefield or the theatre of war. And the Secretary General referred to the interplay of international humanitarian law and international human rights law. We looked at new weapons technologies and the effect it has on our current understanding of international humanitarian law. We looked throughout the day at the role which IHL plays in protecting civilians and the extent to which the role of civilians has changed as international and non-international armed conflicts have changed in themselves over the years. We have recognized, unlike the past, that the majority of armed conflicts today are perhaps non-international in nature, which inevitably invokes different international legal provisions. How, if at all, does this affect a state's obligation in respect of international humanitarian law, mindful that there are other actors involved in armed conflict, not just state, but non-state armed groups? There are also other groups which participate in the theatre of war through one way or the next. We spoke about private military and security companies. How does the law regulate this? These are all challenges to international humanitarian law. We spoke about new means and methods of warfare and taking advantage of technology to the best of our possible resources to even undertake a telephone lecture from Pakistan by an expert on the use of drones. We also had resident expertise speaking on this issue. Many questions had arisen from this panel. Is international humanitarian law an adequate form of law to treat with new weapons technologies? How should we respond to the development of the use of drones, automated weapons, and who knows what tomorrow will bring? The whole other aspect is that of cyber security and cyber governance, which was also discussed. Most importantly, in respect of IHL, is that of cyber warfare. Should we develop a comprehensive treaty to deal specifically with cyber warfare, or should we rely on the principles espoused by the Hague Conventions, which of course have found themselves in additional protocol to the Geneva Conventions and certainly in customary law? Or should the global community react differently to take the debate forward and establish a standalone convention? This is something that was also discussed. Mr. Chair, on the last session, we looked at the role of civilians in armed conflict. The Attorney General of Sri Lanka delivered a spirited and practical lecture on the effect of armed conflict, and perhaps, as he mentioned, based on his own experiences also, on civilians, but also on members of the armed forces participating in hostilities. The issue of voluntary and involuntary human shields was raised. How do we treat with especially involuntary human shields in international humanitarian law and international criminal law, for that matter? And then we looked, of course, at the role and the changing role of a civilian in armed conflict. This revolving door of protection, which could be invoked, which Professor Susan Lamb so eloquently outlined through case law, particularly from the ICTY, on how this concept of the threshold of harm and belligerent nexus could be referenced to the participation in hostilities of a civilian. Mr. Chair, there are many legal issues and practical issues which remain unsettled. A very relevant question from a participant yesterday was that of the Gotovina case, and whether this court-imposed 200-meter radius is considered reasonable, which will allow, from a juridical perspective, to determine proportionality in the law. This too is unsettled. And so, Mr. Chair, on concluding the last session yesterday, the moderator of that session, which happens to be me, sir, I must apologize, had put a question to the workshop. Even after the debate, is law enough? How is the law understood on the field in the heat of the battle? Law to operational doctrine equals practical effect, which, in my humble understanding, is the real purpose of the law. To protect those who participate in hostilities, because even those who participate in hostilities are protected to an extent under IHL, but also to protect those who do not or no longer participate in hostilities. I thank you for the opportunity, Mr. Chair, and I hand the mic back to you.
Well, thank you, Charles, for this recap of what is obviously a very rich debate, and I hope we can continue it today. May I begin by expressing my appreciation to be invited once again to participate in an ALCO function, and pay tribute once again to Dr. Mohammed for the inspiration he has brought with his presence here in Delhi to the international law community as a whole. One more example of it, this workshop. But also I wanted to take the advantage of this Human Rights Day to pay tribute to Mrs. Wirtz and all her colleagues in ICRC, not only for today and yesterday, but for every day, 24/7, for what they do in our joint purpose to safeguard civilians and other protected people in this very difficult field of armed force. 3 years ago, I participated in the workshop Dr. Mohammed mentioned about contemporary challenges to international human rights law and humanitarian law. And on reviewing my thoughts at that time, I can say, of course, many of the problems remain the same. The main problem would be, and it's a recurring problem, to ensure respect for international humanitarian law in the very complicated scenarios which we've been hearing about yesterday, and as a recap by Charles showed us. But even in that short time, we have new emerging problems, and I'm glad we had a discussion on that yesterday. The ICRC has been very active in addressing these new emerging problems. In the report, which came out shortly after the seminar I mentioned to you 3 years ago, the ICRC identified some of these contemporary challenges, and many of them we'll be discussing today as well as the discussion yesterday. The notion and typology of armed conflicts. We heard even yesterday about nanotechnology and what effect that will have on the future. The interplay between international human rights law and international humanitarian law. In this regard, I wish also to pay tribute to the contribution of the ICRC to the development of the International Criminal Court Statute, which Charles mentioned I was very involved with. The International Law Commission has the pleasure of serving during the summers just 200 meters from the headquarters of ICRC, and benefits very much for the intellectual interaction with them, particularly in the work on the International Criminal Court and on the draft Code of Crimes Against Peace and Security of Mankind. One of the problems we had since then, and we found in the various criminal courts, is the somewhat the fusion of the international human rights law and international humanitarian law, and I've written elsewhere about the dangers involved in this. We heard yesterday about some challenges to the protective scope of international humanitarian law. I could add to what we heard about the challenges faced by those involved in humanitarian assistance. I had the honor of being the first chairman of the National Commission on International Humanitarian Law in Iceland. Now people would wonder if you know about Iceland. Iceland has no armed forces. Unfortunately, has had no internal conflict for at least 600 years. You would wonder why would Iceland have to have a commission on international humanitarian law. But it's precisely because of this changing nature of interactions in the armed forces field, in the use of armed forces, and the various new scenarios of international armed conflict, that Iceland, in its involvement in humanitarian assistance and in peacekeeping and so forth, meets those challenges. And I would say, continuing on from that, how useful it is for people like you, many of you, of course, and most of you, nearly all but 2 or 3 of you, are not in potential combatants, but are policymakers. It is as important, I think, that policymakers be acquainted with humanitarian law. And one of the first acts of the Icelandic Commission was to have a training seminar sponsored by the ICRC for all Icelanders involved in humanitarian work. And in this connection, I should add that when I took up the position in the United Nations University for Peace, the ICRC contributed to a seminar, a certificate course on humanitarian law. So all graduates of that university in international law and human rights have a certificate in international humanitarian law. Again, I thank ICRC for contributing to that. But I have to add also, as I welcome our new colleague from UNHCR, that university also provides a certificate course on refugee law. So I thank your colleagues for that as well, and welcome you to Delhi. Finally, amongst the issues that we hope we can discuss here, or in addition to the new means and weapons of warfare, the challenges caused by the transfer of weapons. I know the ICRC is now very much involved in the Arms Trade Treaty, which I think is probably the next step to prevent, to ensure that arms and ammunition transferred to combatants do not end up in the possession of persons who are likely to use them to violate international humanitarian law. Finally, if I refer to the old adage that hard cases make bad law, I think we all face a challenge in the human rights field and in the humanitarian field about the conflation of law and the humanitarian law, human rights law, and the efforts to combat terrorism. And this is a challenge which I think will be faced for quite some time. So having said that, I'd like to pass on to our speakers, and hopefully you'll have time afterwards to continue the discussion with those of you on the floor. But first, I ask Dominique, would you make your presentation and talk to Gandhi before?
Thank you. Good morning, dear delegates, participants, ladies and gentlemen, and I wish you a happy Red Cross Day, which is today. I'm very much pleased to be here with you this morning and to contribute to the ongoing discussion and exploration of issues around international humanitarian law and contemporary conflict. I must confess I'm a little bit awed to be in the presence of so many fine legal minds, because the law and myself, we parted ways somewhere around the second term. So you will forgive me if perhaps my elaboration is a little bit more focused on the operational linkages, and perhaps also to explore how some of the challenges that we face on the ground, how they play themselves out, which I hope will also give you sustenance for the continued legal discussion. I plan to talk about broadly 2 areas. First, to look a little bit at the commonalities, but also the complementarities between international humanitarian law and the body of international refugee law, which primarily centers around the Refugee Convention. And I then would like to zoom in on some of the more operational challenges that I spoke about. When I refer to those two, with your permission, I will just abbreviate them. So let them be known as IHL and IRL. Starting off with the conclusion, IRL and IHL make for very comfortable bedfellows. They are very closely aligned in terms of their scope and their purpose. And when I say that, to bring it down to its most simplistic expression, both bodies of legislation are around protecting those who are protected. Its most simplistic interpretation, those caught in a conflict are supported through international humanitarian law. Those fortunate enough to be able to escape that conflict would broadly fall under international refugee law. Now, as I said, that is a very simplistic delineation. And as I go through the presentation, I hope you will see that in real life it ain't so neat. Because very often that distinction is a gray zone as opposed to a straight line. Coming back to the commonalities, both as civilians and as persons who don't enjoy the protection of the government, refugees are protected by humanitarian law treaties and by customary law in the context of both international and non-international armed conflict. So that's already, in terms of the overall convergence, I think that's the basic starting premise. Now, refugees, of course, as you will recall, according to their definition of the convention, they have crossed an international border. That is a key element of the definition of being a refugee, having crossed an international border. There's other elements of the definition that are very relevant, but I think that's an important one to zoom in on in the context of complementarities. Now, that clear distinction of crossing an international border may not always work as clearly as being a victim within conflict, crossing a border, and becoming a civilian in need of protection, because we have many conflicts across the world where basically refugees flee from one conflict zone into another one. They seek protection from one conflict, but find themselves in the country of asylum embroiled in another conflict. I will throw in a few examples here and there just to illustrate the point. Somalis currently fleeing from the conflict back home into Yemen, for instance, may find themselves moving into another conflict zone, where again basic protection is difficult to sustain depending on what area they end up in. There's other examples where refugee movements essentially carry the conflict with them. You remember in the early 90s, the Great Lakes situation, the mass exodus of Hutu refugees from Rwanda into DRC, and subsequent events that played themselves out in the DRC. It's a very good example of demonstrating that the border, in effect, has no bearing on the scope of the conflict or on the delineation between victim of a conflict or subsequently refugee with special protection requirements. Refugees are protected by international human rights law and domestic law in situations of armed conflict. IHL will apply to them as civilians if they have not participated directly in hostilities. That's also an important paradigm that's expounded in the guiding principles on internal displacement, something I will come back to in a moment, because of course that's the other big distinction, that we're not just talking about refugees crossing a border, but those displaced within the country in conflict and suffering very similar protection challenges. Now, in relation to IDPs, internally displaced persons, as I said, their protection challenges the kind of situation that they experience is actually very, very similar to that of refugees, minus the international border. So they find themselves displaced, uprooted from their homes without being able to avail themselves of the support of their respective authorities, but still in the country of origin. And here the international regime, the refugee regime in a way, is somewhat suboptimal, because the kind of protection arrangement, the kind of legal instruments we have in place are not as strong as the Refugee Convention, which assigns very clear responsibilities and designates clear lines of response to a refugee situation. That legal clarity is not there with IDPs. And of course, part of that is to do with the political dimension, that this sits directly at the issue of national sovereignty and the respect for a member state's right to manage its own affairs. As a result, operationally, in the UN system, there's also a continued complication in terms of who is involved in those operations, who then leads the response to an IDP situation, and who manages this. Many of you will have come across the so-called cluster system, which is basically the formula through which the UN musters its resources and tries to support those who find themselves in internal displacement. On IDPs, therefore, given the lack of clarity on the refugee law side, it is really IHL that is in the forefront, that plays a role in preventing displacement and the protection of IDPs. There's also a clear prohibition of displacement unless justified for the security or imperative military necessity. IHA also clearly stipulates protection of the right to life, dignity and freedom of IDPs, protection of civilians, attacks on civilians by the parties to the conflict, education, humanitarian assistance, and so on. Now, one interesting aspect here is that from our perspective in terms of IRL, the refugee law, what underpins our legal construction. Sorry. I will continue if that's okay. What underpins our legal case is the notion that there is a right to asylum. This is also a basic human right contained in the Human Rights Convention. But the interesting issue is there actually a corollary? Is there a right to remain? Is there a right to remain in safety in one's regular abode and not be displaced? And here, of course, from both sides, IHL and IRL, there have been efforts over time to try and come closer to this issue. We wouldn't call it conflict prevention. We would refer to it as efforts to try and stabilize populations, to try and strengthen community resilience so that the causes for displacement may be minimized. There have been many examples of interventions of this nature in our history. There's initiatives like in the former Yugoslav republics, the so-called Right to Remain initiative. There's also initiatives at community level, Imagine Coexist, is others, and the concept remains alive today. In our engagement with IDPs in Colombia, for instance, there is direct effort to try and reduce the vulnerabilities of communities so that the threshold for them to take flight and to move from their regular abode is somewhat lowered, so that the likelihood of displacement is mitigated. Let me make three very short points on the complementarity of IRL and IHL. First one, the binding character of IHL in its application to non-state armed actors is crucial for refugee protection. Refugee law applies to states and not to dissident groups, and in such cases, IHL provides protection to displaced persons caught up in situations of armed conflict. So you can immediately see the convergence we have here. Second, IRL compensates for non-respect with IHL provisions. And this is a very interesting logical construct. If you think it through, our notion of conferring refugee status to victims of conflict is based on the inability or the unwillingness of parties to a conflict to apply IHL. So in a way, the machinery that confers, sorry, machinery is the wrong term here. The procedure that confers refugee status to victims of conflict, that assesses claims of persecution and so on, is almost a mirror image of the inability to provide that protection in the country of origin. So there's a direct correlation, if you will. Third point, as Article 9 of the 1951 Convention authorizes a state to derogate from refugee protection in time of war, IHL contains important complementary safeguards and urges states to show great restraint in applying special measures to protected persons. So again, here you can see the connectivity between the two. Let me now move on to perhaps a bit more operational look at some of the implications that we see in our operational environment. First off, by way of backdrop for those of you who may not be too familiar with UNHCR's approach, in addition to being the custodian of the Refugee Convention and its assorted legal frameworks, UNHCR, of course, has a very strong operational role as it tries to bring about solutions to the refugee problem. So it is not just an issue of recognizing a refugee and trying to support that refugee while he or she is in exile, but also to be able to bring about a solution to the problem. And very briefly, the topmost solution here is a return to the country of origin as and when the situation that caused flight has ceased to exist. Secondly, it is to support the local integration in the country of asylum to the extent that the refugee is unable to return. And the third one is the so-called resettlement procedure, which allows in a very few cases recognized refugees to be moved to a third country and reside there permanently. Those three solutions we try to apply in all refugee situations. What you see on television, what you see as the brief on refugee operations is usually the emergency context, it's immediate outflows, a situation arising from an ongoing conflict, convoys of refugees crossing a border and being supported in the context of humanitarian assistance in refugee camps. Our reality is that more than half of the refugees under our care have been in camp situations for more than 5 years. And that's a little bit the threshold beyond which we refer to a refugee situation as a protracted one. It is protracted because it does not lend itself to one of the three solutions. There's no prospects for return. It's very difficult to support local integration for whatever reason. And there is not enough uptake from the key resettlement countries to take in those refugees in that situation. And here, sometimes we see a direct correlation between a protracted conflict and a protracted refugee situation. Afghanistan sometimes has been referred to as a protracted conflict, and as a result, the huge refugee populations in Iran and Pakistan, respectively, de facto constitute protracted refugee situations. However, that's not an exclusive link. There are also refugee situations where the conflict in the country of origin has long since ceased and the refugee situation continues to persist. I'll give you one example from the region here. Bhutan has had an outflow of its population in the early 90s. Those refugees find themselves in Nepal. And although the situation in Bhutan is considered to be very conducive, the refugees are unable to pursue a durable solution, a solution in line with the three options I've just outlined to you. So that's a situation where, again, the international community rallies around, tries to come up with a judicious mix in order to resolve that particular refugee situation. Perhaps perhaps one last word on this particular context. For refugees, this constitutes a double jeopardy, being in a protracted refugee situation, because their country of origin is not able to provide them with the basic protection that they deserve as citizens, and in their country of asylum, they are unable to enjoy the full rights as refugees or avail themselves of options to integrate fully into the society. So it is one of those areas where the mix and the complementarity I spoke about earlier of IRL and IHL does not adequately support the individual victims of conflict. In terms of a second challenge I would like to flag, this one relates more to the issue of obtaining humanitarian access, something very topical for humanitarian actors like ICRC and UNHCR. In situations of ongoing conflict, how do we reach populations caught in that conflict? How do we navigate that minefield of maintaining neutrality, impartiality in an environment where neutrality and impartiality are almost impossible to sustain? Here, there are a number of factors to consider. One of them is, if you look at the evolution of armed conflict over the past few years, let's say the past decade or so, you will notice that, of course, the ratio of conflicts between non-state actors has gone up quite significantly. Between 89 and 96, only 5 of the 96 armed conflicts that took place worldwide did not involve non-state actors. In other words, 5 out of the 96 conflicts were traditional intrastate conflicts. Yeah? I think that very clearly shows the trend, and very clearly shows that perhaps some of the old tools in our box in terms of how we interact with state actors may not apply, may not work as well in a context of basically a whole new environment with an increasing number of non-state actors. Coming back to the challenge of access, what it means, and I want to give the example of Somalia here. Some of you may have followed the big challenges faced by the international community in delivering aid inside Somalia over the past few years, where humanitarian agencies were basically caught between a rock and a hard place, for want of a better description. To deliver aid to needy population, to extend effective protection to people in need, agencies had to operate through the non-state actors in charge. Al-Shabaab, the offspring of Al-Qaeda in Somalia, which effectively controlled the territory. In order to negotiate with this non-state actor, inevitably, the very fact that a negotiation took place conferred a modicum of legitimacy and loss of impartiality in the process. To make matters worse, many of the actors were obliged to pay taxes in order to be able to deliver humanitarian aid into affected areas. So it's an example where basically the protection of civilians in this environment is extremely stressed by the absence of clear regulatory guidance, if you will, how to deal with those situations. And at the end of the day, it's a judgment call. It's not necessarily an application of a legal provision, but it is a judgment call of the operators on the ground, how they meet the humanitarian imperative in this kind of operating environment. Let me perhaps expand a little bit on the challenge of maintaining independence, neutrality, and impartiality. For us in the UN, this sometimes becomes even more complex because we are asked by the international community to combine our assets, our resources, our capabilities in a concerted effort in conflict situations. You will be aware that in many conflict situations, peacekeeping missions are deployed, and that there has been a trend of years over the years to try and introduce other assets, including humanitarian capabilities, into those structures, to try and ensure that the combined effort of the UN system pursues a single purpose, that there is a clear thrust towards stabilization in that country. What that means at times for principled rights-based actors like UNHCR is that we fall into a command structure that is essentially pursuing political or strategic objectives. And there's a textbook example of this situation coming from Liberia during the heydays of the Taylor regime, where there was a clear mandate for the UN peacekeeping mission to try and support, even with force, a reconciliation process and a political process that leads to a conclusion of the fighting, which meant that the SISG, the Special Representative of the Secretary General, used all means at his disposal to do so. It meant that he instructed humanitarian agencies not to engage with a particular population group. So that, of course, poses a tremendous challenge to an actor like UNHCR, that is rights-based, that is following humanitarian principles in this kind of environment. I think in that context, our kindred spirit, ICRC, is protected in a way of operating in an environment that requires us to accommodate multiple objectives, and at times requires this kind of compromise. Let me talk briefly about, because it builds nicely on the notion of humanitarian challenges and challenges to impartiality and independence of humanitarian action. It's really the case for wholesome action. It's the notion that we try to do more than deliver a band-aid. We try to do more than just deal with the outcome of conflict and the basic restoration of rights for those who have succeeded in crossing a border or those who have been displaced within their own country. It is a need to really look at the entirety of the interventions that restore the basic rights of that individual. So that is a case to expand the scope beyond the immediate rights-based approach. I think there's also an ongoing case, and in a way that's an obvious conclusion to present to you, to continue to strengthen linkages between IRL and IHL. There's many good examples of ongoing work. Armed conflict, after all, is the principal cause for refugee flows, and it is the principal cause for mass refugee movements. And perhaps I could make a quick reference to India in this context. India, as many of you know, is not a signatory to the Refugee Convention. This is a historical argument because India felt at the time that the convention was negotiated that it was a bit of a tool of Cold War one-upmanship by way of defining a refugee as an individual who has been obliged to flee from persecution, and as a non-aligned state, India did not want to accede to that construction. But India has always maintained that, of course, refugees who move en masse, who move as a group, deserve protection and need support. And India has lived by that spirit and has accommodated huge refugee populations from neighboring countries over time. And in fact, the notion of a mass movement has later on found its expression on a different continent in the context of the OEU Convention on Refugees. The OEU Convention expands that notion of a refugee definition and applies it to groups who flee from conflict. Somalis who run today across Somalia's border into neighboring countries are recognized on a prima facie basis, which basically means we know what is happening in your country, no questions asked. It's no point to subject you to an individual interview to determine what exactly has occurred in your situation. There's many points which I believe warrant further legal assessment in terms of supporting the cross-fertilization between IHL and IRL, particularly so in the context of IDPs. As I suggested earlier, compared to the refugee regime, which is comparatively well articulated on the support and legal framework for IDPs, that is relatively less developed and needs much further attention to come up with a strengthened network. Let me try to draw it to an end and perhaps try to find a similar tone as colleagues earlier. Our legal systems and our perceptions of how legal systems evolve, they change, and they change in line with the realities that we find. We're discussing in this symposium, there's changing realities in the nature of conflict. There's new elements that are introduced in conflicts that require constant reflection and adaptation. The challenge for us will be to keep up with the changes in the nature of conflict and to maintain an open system that tries to reconcile the normative framework, if you will, the legal architecture, with the realities on the ground. And I'm making this point because ultimately our legal frameworks, they serve but one purpose: to protect the individuals affected by conflict, to protect the unprotected. So there is a case to be made to also constantly test, validate, and ensure the applicability of our concepts, of our models, in the reality of conflict victims in war situations, and to ensure that the colleagues operating in those environments are able to come up with very pragmatic and proactive solutions. Let me conclude on this note, and thank you very much for your attention.
Well, thank you so much for this very lucid exposition, particularly the way you phrase it in terms of practicalities. And of course, those of us in the legal profession are very keen to hear the relationship between law and real life. And I think one of the factors that you mentioned, the tools are legal, but they have to be applied dynamically and taking account of changing circumstances. And I appreciate very much the way you ended up in your presentation. I think 20 years from Rwanda, it's a good reminder. This is the way we have to ask. And I said that I'd like to give the floor to Dr. Gandhi, please.
Thank you very much, Your Excellency, Secretary General, for providing me this opportunity, and also the Chief of the ICRC delegation here. And thank you so much for Ambassador Erickson, as well as my friend Dominique, co-panelist. It's so interesting to listen to the complementarities between the refugee law and the humanitarian law. Now, the topic I'm going to discuss is well known to you. That is the contemporary challenges to international humanitarian law. The chair was mentioning about 3 years ago there was a report that was released by ICRC. That was circulated in connection with the International Conference on Red Cross and Red Crescent. It identified the following challenges. And those challenges remain challenges, and some more challenges are deepened. That's the only difference I could see. And what are all those challenges? First, criteria for the determination of international armed conflict. Then classification of armed conflicts into international armed conflict and non-international armed conflict. Armed conflict combined with terrorism. interplay between IHL and human rights law. Now we have seen the interplay between the refugee and IHL also. Extraterritorial targeting of persons, and where we can find many forms. What are all practiced in Afghanistan, what are all practiced elsewhere. Then in that context, the civilian population participating in armed conflict also will come into play. Then humanitarian access and assistance, law of occupation, IHL and multinational force, private military and security companies. These are all the you can say the entire spectrum that has been brought before for discussion. I understand that in the yesterday sessions, some of them have been discussed. Now let me focus on 2 or 3 components of the contemporary challenges, because beyond that the time will not permit to go. In addition to that, I read another interesting article by Rosalind Dickens, very recent article, that says that new challenges and the International Court of Justice, that is new challenges brought before the International Court of Justice in the area of international human rights. These are all due to fragmentation of international law. We are well aware that different courts are coming with different decisions. And most of the decisions you can find there, and these are all relating to, again, international and non-international armed conflict. And you can see the ratification part of the Geneva Conventions as well as the additional protocols. You can find that the region in which we are here, that most of them are not party to the AP 1 and 2. And most of them are party to 1949 Convention. So we have to give more focus on that, why they want to restrain themselves in a way that they want to be only party to 49 Convention and not to be party to AP 1 and 2. And this again touches upon the character of non-international armed conflicts and armed conflicts. And Mr. Dominique was given a statistics that out of 96, only 5 are international armed conflicts. Rest of them are non-international armed conflicts. So if you apply law that is relating to only international armed conflict, this outmoded law is obsolete. So we have to find a way media. And how do you deal with even the parties and who are all only restricted to 49 Convention? And how do you go about creating a kind of a general standard that will be applicable for both kinds of conflict? Because enormously you have now only the non-international armed conflict. The criteria to determine international armed conflict and difference between the international and non-international armed conflicts are identified very rightly the foremost challenge. State-to-state armed conflicts are still happening, but armed conflicts are on the rise today. World is non-international armed conflicts. Of all the challenges mentioned in the report that I referred, more seriously, these challenges is more serious challenge than others, I believe. For international lawyers, it is a matter of common knowledge that the obligation of states under international law is based on treaties to which they are a party, or customary international law must be the basis. In this region of South Asia that I referred that, only very few countries are parties to AP 1 and 2. No doubt that 1949 Geneva Convention play a very important role, because it also has a common Article 3 that deals with non-international armed conflict situation. But what is important here is that states were not originally willing to regulate the non-international conflict under a treaty. That was the reason that 49, there was some reference, only the Article 3 Article 3 was considered as a mini convention by itself, and Article 3 needs to be elaborated. They try to elaborate in AP1, then the AP1 and 2, they want to deal with it, and as far as the non-international armed conflict part is that they want to elaborate it, but when they did elaborate the elaboration, whether they have done it properly or not, that is the issue now. The only concession they were willing to extend at the time was the minimal protection under Common Article 3, which is considered as mini convention. Common Article 3 applies as a minimum to armed conflicts not of an international character occurring in the territory or the contracting parties. While the conflict must take place on the territory of the state, it does not have to involve armed forces of the state. You know, the reference is parties to the conflict. That is the phrase they used. And they have done away this phrase in the additional protocols. But how it works in practice. A closer look of Common Article 3 would reveal that obligation imposed on state parties under the convention is more general in nature. A recent study made by T.M. Asser Institute on Common Article 3 says Common Article 3 sets out number of rules which must be applied during an internal armed conflict to which normally the Common Article applies. But the article does not specifically specific conditions in which it applies, nor does stipulate that the conflict must be of a particular scale or duration. Now the test comes in here, they call what they call intensity test. According to ICRC commentary on Common Article 3, certain conditions must be satisfied before Common Article is applicable, including the requirements that non-state actors possesses an organized military force and act under an authority responsible and within the determinable territory. Nonetheless, these criteria are non-obligatory. The real problem concerning non-international armed conflict is its determination as to at what point does a conflict become a non-international armed conflict. As a term, armed conflict has not been defined. It is a challenging task. In the absence of definition of armed conflict, it is left to the states to whether an armed conflict exists or not. According to Jean Pictet, conflicts where armed forces on either side engage in conflicts, similar to international war, which takes place in the confines of a single country, would attract the application of Article 3. However, according to another authority, civil conflict and rebellion cannot be treated as non-international armed conflict. There is a restrictive word here. Nonetheless, states can deny the applicability of Common Article 3 to a situation of armed conflict in times of disagreement as to existence of non-international armed conflict. The only applicable criteria is the intensity of violence. The intensity is in fact referred in a different way in that case, that is the Protracted Act of Violence. There was a reference by Dominique about the Protracted Act of Violence that can be taken. In practice, drawing a line of demarcation between interstate and intrastate armed conflict is not that simple. Professor Disdain